Welcome. I'm Rudolf D'Souza, your host on today's webinar by My Nation Hope Foundation. Thank you for being with us today. We appreciate joining us on every Sunday on different topics and Men Ki Baat. Why we are making Men Ki Baat? Because our media is not ready to show men's issues, men's problems, what they're facing in their life, what they're facing with our legal system. So we decided to air our members' stories. These are not cooked up stories like feminist shows, not fake statistics or fake details. These are real stories, real men, how they are troubled, how they are harassed. That's what we want to show. Today, here with us, our member, he is also harassed like this only. We'll show you none of the questions or whatever. We didn't ask him to prepare himself. These are the real-time questions. We are asking about his case. We are not making any, we are not training him. We are not telling him to tell like this, just like others, mainstream media about feminist or women empowerment or women ministries are producing on the TV or social media. He is telling his real life. Today here with us, Mr. Vikas Singh from Andheri, Mumbai. Mr. Vikas Singh, welcome to the Men Ki Baat.
Thank you,
Please
Rudolf.
introduce yourself.
Hi guys, I'm Vikas Singh. I'm born and brought up in Mumbai, Andheri. So I'm facing several criminal cases, and I'm facing divorce case. I'm facing DV case. So
Okay.
not only me, my whole family is facing.
Which year you got married?
I got married in May 2019.
2019. Okay.
Yes.
Okay. How long you have been together?
So I was with this girl like 2 years. I knew the girl from 2 years. She had like
before marriage. Before
yeah.
marriage.
Yes. No. Sorry. Before marriage, it was one and a half year, and during that period, everything was for the initial 1 year. It was all strawberries, and then in the last 6 months, the real story started coming forward bit by bit. So they even tried to file a 376 on me in Bangalore, the rape case. After which they forced us to get married. And as soon as the marriage was performed on 12th of May 2019, the same day,
Okay.
after an hour of marriage, I was asked to give divorce and 1 crore as an amount to do the settlement.
Okay. Dr. Vikas, I think a banner is not displaying. Someone is browsing the PPT.
Don't worry. No, don't worry. In streaming, you can only see the banner.
Okay. Who filed the case on and which case filed on you? Because
So as I said earlier, the girl tried to file 376. After that, after marriage, within 2 months, the marriage was on 12th of May 2019. On 19th of August, exactly after 3 months, she filed section 377 and 323 over me. So
okay.
yes, and
377 and 376.
323 after marriage.
323. Okay. 376 is rape case. Okay. Was there any evidence she produced?
No, there was no evidence whatsoever. She actually so the story is somewhat like she even went to Bangalore again. So in April 2019, she first tried 376 on me. When that didn't happen, she said to get married. Okay, we got married. The same day she asked for divorce, and she started all the trauma. She started physically abusing me. Not only the physical abuse, I even showed the videos to the IO, the physical abuse video, but the IO laughed and did nothing about it. And
This shows she wanted to marry to show that she is married to you. That means she is filing a false rape case on you without any evidence to pressure you to get married. She think this marriage will be with a happy ending or you live together. It's not like that. She just wanted to make some grounds to
Yes.
claim maintenance tomorrow, to make money. Because our media, many times we see in the news that the even women NGOs, some good women NGOs, they are telling 85% of the rape cases are false. This is another evidence. We have live evidence here, our real member. This is not a fake story. This happened in real life. This is how our law is supporting women. They are not making gender equal laws. Men cannot defend when a woman is falsely claiming she is raped. Police will register this case, and man has to fight, run post to pillar to justify, to show, to prove he is not guilty, he is not wrong, he done nothing wrong. This will take decades, but still our law system, our lawmakers, our politicians are sleeping. Knowingly, the 85% cases are false case. And recently, I think 15 days back, in Maharashtra, they wanted to make Shakti law, Shakti Act, new law. There are plenty of laws for women. They want to make more and more laws to be abused, misused, and harass, just to harass men. This is showing one more case, and this is also from Bombay. So this Shakti Act will affect many Maharashtrians. That's what we want to show, how these false allegations affecting men's life. But our lawmakers, no, they are after money. They are selling public property to businessmen. They are after their own PR. They are not doing anything for men. There are thousands farmers are protesting. They are not listening to them. They want their own agenda. They are not, we men, I'm doing this for last 20 years. Writing, sending mails, writing RTIs, sending RTIs, but no one is listening. Our politician, they want only woman empowerment. Beti Bachao, just to get vote, nothing else. They are not listening to men's stories. This is another evidence. He was forced to marry on the threat of rape. Then next day she is asking for divorce so she can demand maintenance. It's all about money. Anyway, so after marriage, how many days you were together?
So after marriage, Rudolph, I started staying with her, and not only after marriage. So I'll tell you what happened. So we decided, okay, to get married, and then we thought, who will fall into this criminal cases? We will run to the court to get the justice, because we all know how the Indian judicial system works. So I came back to Mumbai on 22nd of April, 23rd of April. I reached Mumbai, and my parents disowned me, and that was a good thing, I believe. And
Because you got married without their blessings?
no, it was yes, we can say it was a part of that, but apart from that, it was that they knew that they someday if they are going to accept me, they are going to accept her. She's going to file even more criminal cases on me and maybe on them as well.
Okay.
But me being a guy who was into IT, I was afraid of the criminal cases. I thought my career would be over. I decided to get married to her, and so we started staying together from 23rd of April together. Me and her, only me and her at her place.
Where? In Bangalore or in Bombay?
In Mumbai, in Navi Mumbai.
Okay.
Okay. My parents never stayed with that girl. My family never stayed with that girl, not even for a second.
You were staying in a rented home.
Yes.
Okay.
We were staying in a rented home. Then, as I said, after 3 months, she actually filed the 377, 323. But before that, she actually tried filing rape case. She went to Bangalore after marriage. That is in August itself. On 6th of August, she went back to Bangalore and filed a private complaint in which she alleged 376, 420, 417, 407, 504, Section 2, like this, all big criminal cases. She filed over me in a private complaint on 6th of August. And on 19th of August, in Mumbai, she filed 377, 320. Yes, I was in Bombay only. I was not aware even about the private complaint which was actually running over then on 6th of August 2019.
Without your knowledge, she went to Bangalore?
Yes.
Okay. What is the reason to file all these cases?
Sorry, reason was simple. She wanted 1 crore as an amount, or she said, if you cannot give me 1 crore as an amount, why don't you do one thing? You ask your parents or your brother to transfer a 2 BHK flat in my name. That's all we're done. Then she said, if you don't do that, we'll fight in a contested manner, and it will take 5-10 years. Then ultimately, you're going to check out the money. You have to give me the money back.
That shows these women cannot count more than 1 crore. Why 1 crore? Why that amount?
Maybe there are lawyers who are there who are trying to make it look like that it's so easy to get money out of men by filing cases, and that's kind of a fact. Men actually generally give in. Men generally give in. They don't fight, and
they know whatever amount they are asking. Our judges are awarding all the maintenance, whatever maintenance. I think we have to ask our WCD and NCW to teach women to count more than 1 crore. So at least they can ask more.
Yes.
Please, whoever is there, the ministers, Rekha Sharma or Smriti Irani, please teach these Abla Naris to ask more than 1 crore. Okay?
Mm-hmm. And
it's a shameful. They are asking 1 crore. They should ask 100 crore, something like that.
Mm-hmm. So, Ruf, after that, I was arrested. Actually, the IO did. IO called me and she said that she's trying to file 498 on you. Why don't you come with some evidence so that we don't take 498? I went to the police station in Navi Mumbai.
Okay.
And they immediately arrested me in the night, and they arrested me, and I was put into.
They served any 41A notice or anything?
Nothing. When I asked her about 41A notice.
This is for New Bombay Police. Without serving any 41A, they are calling you to mediate or to give some evidence, and they are arresting you. That's how our police are, Mumbai police are doing. This is. They are breaking the law. They are not protecting the law. To show they are the good police. They have many times they come in the media and say we are better than Scotland Yard and blah 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 blah. This is the pathetic situation our police are doing. They are calling and without proper legal procedures, they are arresting. They want to threaten, they want to, I don't know, or they ask money or I don't know. But most of the cases, they are doing it for money. When you pay something, they will release you. Next day, they will again call you just to bring something. Otherwise, we'll charge you. This is the situation. So after arrest, what they produce to the court within 24 hours?
Yeah. So what happened is the night when they arrested me, when I asked for 41, they said that 498A is not filed. Only 377, 323 is filed. Will not give you 41A. You are arrested, and tomorrow we'll produce in front of magistrate. It was done. I was not allowed.
376 filed in Bangalore, right?
Yes.
Why New Bombay police are arresting you?
No, sir. So it was two different cases she filed. So she filed 376 in Bangalore, and she filed 377, 323 in New Mumbai. So that's like two different cases at two different places. She did that.
There she filed a rape case. Here in New Bombay, she filed 377.
Yes.
377 she filed.
Exactly, 377 she filed.
Okay, that is unnatural sex. Okay, well, she produced anything, any evidence, any MLC or any medical report, anything?
No, no, nothing was produced. I was immediately arrested.
Then how police can arrest you and take charge, take our complaint?
Yes, when the question was asked, they said that after arrest only this all procedures will be done.
They have to verify. Only after verifying they find it's a true, then only they have to take action. Not because there are encounters. They cannot just shoot someone saying you are a criminal, you are a terrorist. Okay, they have to show the proof tomorrow. Where is the proof? There is no evidence. How can they? This is a human right violation.
This is actually human right violation. Even they took me court early so that my lawyer was not able to defend me the next day.
Mm-hmm.
Instead, they hired somebody from their own as a lawyer, and that lawyer just stood there and just said one thing: "Ma'am, it's a false case to the magistrate.
Mm-hmm.
Please grant the bail." Just this two sentences, nothing else. The bail was, of course, rejected.
Was there any domestic incident report they filed?
No, nothing. Domestic incidents report, DV is running till now. Even after 1 year, there is no DIR.
Okay. That she filed again later?
Yes.
Okay. What she is asking in DV?
So she filed DV. She's asking 30,000 a month, and as an interim, and 25 lakh as a compensation, stating she's not earning even a single penny. Because she's so much disturbed. She went to some private psychiatrist, and got some medicines for anxiety and sleep. And she's producing those prescriptions into the court, and even got an order done, which I came to know later, which was taken on board. And she got the order done for the residence order. She was brave enough to do perjury on the affidavit stating she is not earning.
Okay. And she is working?
She's working. She's earning somewhere around 94,000 a month.
Okay. Still, judge is not taking perjury.
When we came to know, we have now went to the session court as well. We have filed an appeal, and into the MM court, Thana MM court, we have also filed perjury. He has taken the perjury for now. He has said the opposite party to provide their say. Most probably next date, they'll file something rubbish into the say. Or they would say that they don't want to run the perjury now, it should be run later. That is what generally the tactic is.
No. There are high court and higher court judgments. 340 should be tried first. It's not later. Okay.
Right.
He has to decide. Judge has to decide 340 first. It's not later. When someone is coming to the court with unclean hands, they should be punished. Not award maintenance and we'll say later we'll try 340. It's not like that. This is not legally valid. Anyway, our judges will do as their own, because they are doing favor to women. Okay. And even men are true, right? They will not listen to them. And this shows the incident shows how she was manipulating. She is coming to the court with unclean and fake stories, soap stories. Still, our legal system is listening to her and wasting public money. She get public prosecutor to defend her. She get lawyer. She will say, I am penniless. I want a lawyer. Government will give free lawyer to her. Even she is coming to the court with all false allegations, fake stories, just because she is a woman. Here in India, women are treated like endangered animals. Okay, that's how they are protected. Whatever they say, it's right. Whatever you say, whatever, they will not listen. Even you are coming with the proof, evidence, video, audio, documentary, whatever, witness, they will not listen. This is the situation of India. This is the situation of Indian men. Anyway, she also filed a dowry case, right?
Yeah, so she got the FIR modified. The same FIR she got modified by providing a supplementary FIR. And this time, after 6 months of modification, after filing of the FIR, 6 months later, the FIR was modified and my whole family was implicated. 307, 498A, 504, 506, 34 was added. My brother, sister, mother, father, brother who she has never seen.
Just to bring pressure on you.
Yes.
Right? Okay. They have nothing to do with, never stayed with you. Still, police are happy to add their names because they are doing favor. Because they have direction from top.
So not only that,
From
she has never seen my
Union
brother.
ministries or law system or whoever. Anyway, hello.
Yes. Yes. She even implicated my brother in the false case, who was not in India all the time.
Okay.
She said that my brother had beaten her, abused her, and all sort of fake allegations. However, at all the time, my brother was not even in India.
Okay. Even he is not in India, they can dream that he came and beat her. And police are taking, our law system is taking such false complaints without verifying. This is the law of India. And they are saying our law is from centuries old. Whatever law we copied from British. So far, no one is able to modify, change as per the current situation. They want to just pamper women. Only they know only Men Ki Baat, only Beti Bachao. There is no Men Ki Baat. No one is asking about men. This is the situation. Okay. After this, she claimed maintenance also.
Yes, she is claiming maintenance under DV. She has now filed a divorce case as well on the basis of cruelty. There too, she has done perjury on, and she has given all the affidavits and all.
You done so much cruelty because you are defending your case. You are not giving 1 crore. She asked so much cruelty. Yeah. You have to be ordered 1 crore.
Yeah, the actual cruelty was that I didn't do the 2 crore car term insurance which she asked.
Yeah, that is the situation. Okay. Has she proved any of her claim?
No, nothing.
Any of her claim?
Nothing.
Okay.
No, nothing was proved, and still we are facing the case. We are going and fighting the case. She sometimes come in the DV case, sometimes she is not coming. It's like her advocate is coming and telling me to settle, nahi to yahi chalta rahega. You will fight the cases. She'll get divorce on cruelty. You will fight for your whole life. So this is the threats which I get from the advocate.
Tell them we are ready to fight. Ready to fight for the justice with this biased Indian law system. Anyway, whatever, they will not, whatever, even they are getting money, they will not happy with that money. Okay. We believe in that. Okay. With this false claims, false allegations, false soap stories, what they will achieve? Just because our law system is supporting them. Anyway, you said the interim maintenance was granted, right?
No, sir. The interim maintenance was not granted. The residence order was granted for the house where she has never stayed.
Okay. Okay.
Because she has falsely claimed that she stayed there and she was beaten up and all. However, she has not even visited my house once.
Okay. No. To grant there should be some reason. Judge has to be. I'm asking last question. There should be some grounds to grant this. It's not like without anything. Just because she is asking something, judge cannot ask grant. So, on what basis the residence order is granted?
So the residence order was granted on the basis of, first, she has taken the matter on board, and in her petition she has mentioned that she is not earning even a single rupee. She is not having place to stay, and she got her friend's affidavit stating that she is staying with her because she is not mentally well, not working, not having any house. So this was taken as a matter of urgency, and the judge saw it as a grave injustice being done to Devi, and he granted the residence order. We were not even given any notice.
And judge didn't verify all this.
No, only an affidavit was taken by her.
Okay. You complain to against this judge to the higher court?
We have filed a revision. We have filed an appeal actually to the session.
Not revision. See, whenever these judges, I don't know. Judges without verifying, just because someone is giving statement, tomorrow you bring with a statement and saying she beat you, they will take action? No, they have to verify. Our law is blind, but judges should not be blind like this.
No, they should not be, but they said like that.
You have any message to our legal system? This is the last question I am asking. You have any message to our biased legal system or our sleeping lawmakers and politicians?
Yes, I have one message to my law system.
No message to our legal system or our lawmakers.
No, I have message to the legal system, the biased legal system, which sees men as a criminal. So the only message is that you need to see men also as innocent until proven guilty, not vice versa.
Okay.
Because we are always seen as a criminal, we are always seen as guilty until proven innocent, and we have to keep on producing evidence to support ourselves. It becomes onus on the defendants actually, even in criminal case, for the matrimonial matters, when there is a girl involved, or even if it is not a matrimonial matter, if it is a normal matter wherein somebody is accused of rape or somebody is accused of 354, I have seen it becomes kind of reverse situation wherein the defendant has to come up and has to produce evidences, witnesses, and fight for 10 years, sometimes 15-20 years, and has to prove himself innocent. And till then he is being seen as a criminal, not only by the society, not only by everyone else, but even by the judge himself. So this needs to change. If a woman is presumed innocent until proven guilty, the men also should be. No blind orders should be filed. As you rightly said, the law is blind. The judges are not. They should not be blind. They should see the facts. They should understand that these the allegations which are mentioned in the petition. If we just go to the court and get some copies, we'll see that these allegations are actually repeated in most of the petition. How come it is possible that sentence A is being said to one victim is being said to every victim? The judge even knows this, but they don't do anything.
Okay. Thank you for your message. Hope our lawmakers, sleeping lawmakers, and the politicians listen to our voice. Someday they will wake up. They will wake up only when they are implicated and accused in such cases. Anyway, they will listen and change something to our law system. Thank you, Vikas Singh. Thank you very much. I wish you will get relief. God knows when. relief from our biased legal system. I
Yes.
wish you best of luck.
Thank you.
Thank you.
Thank you very much, Vinod.
Okay. With this, we completed our Mann Ki Baat, today's Mann Ki Baat. We are continue with our next session, criminal revision. Dr. Vikas Singh, please continue.
Thank you, Rudy sir. Thank you, Vikasji. So our next session is on criminal revision. This webinar will be given by our Dr. Sarvapalli Prasar. Dr. Sarvapalli Prasar is a dentist who's turned legal consultant and currently doing his final year LLB. He has a special interest in matrimonial matters and a Muslim law. So I would like to welcome Mr. Sarvapalli Prasar to start his webinar. Thank you.
Dr. Vikas. Well, I was listening to the guest on Mann Ki Baat. This is the best example of how laws are misused. I just want to say one thing to the speaker of Mann Ki Baat. Just stay strong.
I will, sir. I will.
Just stay strong. Dr. Vikas, shall we start?
Yes, continue, please.
You have to start the PPT. Well, criminal revision. Why criminal revision? Well, let me disclaimer first. The contents on this site, including the reference that we gave, is only for information. Before you use it for for practical purposes or for carrying out legal proceedings, use your discretion, check with your own copy, and then carry on accordingly. We don't, as usual, we don't claim any, neither me nor My Nation Foundation claim any copyrights on any of these PowerPoint presentations. Next slide, please. Now, what is revision? An act of examining again in order to remove any defect or grant relief against irregular, improper exercise or non-exercise of jurisdiction by a lower court. Now, why? What is the object? The primary object of revision is to confer upon superior criminal courts a kind of paternal or supervisory jurisdiction. Carriage of justice, right? See, for our perspective, there is a 498A case, and then you see that there is no prima facie case. You file a revision in the lower court under section 239 of CRPC, and the lower court doesn't exercise its jurisdiction. It doesn't apply judicial mind. It gives a cryptic order. It gives an order which is opposed to common sense, where there is lack of application of judicial mind. What do? You go for a revision. It's your right. See, Article 21 of the Constitution talks about right to fair trial. Right to fair trial under Article 21 includes right not to be subjected to trial when there is no prima facie case. And how do you get that right? There are two ways. One is discharge, the other one is quash. And in several high courts, when you go to high court, directly go to high court by filing a quash, the courts are sending the case back to the lower court, giving an order stating that when there is an option for discharge, why are you coming to the high court for quash to invoke the inherent powers of the high court? So what is the option? File a discharge. If it's a simple 498F where the offence is punishable with imprisonment below 7 years, you go for 239 CRPC. You go for discharge under 239 CRPC. If it is an offence, let's say there is a 304B, and then you feel that there is no prima facie case under 304B, You go to you go to sessions court for discharge under section 227 of the CRPC. And then the court doesn't apply its mind. It gives a cryptic order and then says, see, we have seen several discharge dismissal judgments where the court says, whatever you talk, there are some courts which go to the extent and say, to the extent of saying that you go with the order that there is a delay and there is unexplained delay in lodging the FIR. The court will say unexplained. Well, see, the lower court will say whether or not there is an unexplained delay in lodging the FIR is a matter of trial. You go with the ground saying that prima facie there is no case. The court will say prima facie, whether or not there is a prima facie case is a matter of trial. I'm sorry. This is how. See, there are several reasons behind giving such orders, and I would not comment on them. What is the relief that you have? The relief that you have is to go for revision under section 397, 99 or 401 of CRPC. So the relevant sections for revision are sections 395 to 405 of CRPC. Right? What is the object? The primary object of revision is to confer upon superior criminal courts a kind of paternal or supervisory jurisdiction in order to prevent miscarriage of justice. Next slide, please. Am I audible? Yeah, thank you. Nature and scope. Section 397 empowers High Court and Sessions Judge to call for and examine the record of any proceeding before any inferior criminal court for satisfying itself as to the correctness or propriety of any finding, sentence or order recorded, imposed or passed by such inferior court. Section 398 enables the revisional court to order inquiry in certain circumstances. Section 399 provides that sessions judge may exercise all or any of the powers which may be exercised by the High Court under section 401 clause 1. Right? So the point is, they have got something called concurrent jurisdiction. Both the Sessions Court and High Court have got concurrent jurisdiction, which means that when you're going for revision, you can either go to from a magistrate court, you can either go to the Sessions Court, or you can go directly to the High Court. The decision is a point of judicial discretion. There are several factors that you have to take into consideration when you're going for revision, whether you plan to go to Sessions Court or High Court. Right. Section 401 provides the following four powers to High Court: power of disposal of appeal under 386 CRPC, power of suspending sentence under 389 CRPC, power of arresting the accused in appeal against acquittal under section 390, taking additional evidence under 391 CRPC. Next slide, please. Nature and scope continued. Power of pardon under section 307 CRPC. Looking at the above provisions, it can be inferred that there is no form of judicial injustice which the revisional court, if need be, cannot reach. If need be, cannot reach. So, when you're going for revision, you have to explain how injustice is meted out to you by the lower court. Next slide, please. Conditions. So what are the conditions in which you can go for a revision? First of all, the proceedings must be in a criminal court. Such court must be an inferior court. Such court must be in the jurisdiction of the revisional court. Revisional court must have called for itself about the correctness, legality, or propriety of any finding, sentence. The impunged order must not be interlocutory. Now, what is interlocutory is something beyond the scope of this scope of this session. The order must not be appealable. Next slide, please. Powers of revisional court. In case of acquittal or conviction, it can set aside acquittal or conviction or sentence. It can remand or order for retrial. In case of illegal discharge, it can order further inquiry. It can enhance, reduce, quash, or suspend sentence. It can grant stay against the impunged order till the disposal of revision. It can also stay proceedings pending in any inferior court. It can quash proceedings and discharge accused. It can alter the finding. Next slide, please. Hearing of parties. Section 403 gives an option to a court exercising revisional jurisdiction to hear the party either personally or by his pleader. Such party, however, cannot claim right of hearing. If hearing is not afforded to parties, even if justice is done, it will not appear to have been done. It is therefore sound exercise of to afford hearing to the parties by the court. Relevant case law of the state. So, as per CRPC, it is under the discretion of the court to whether to give or not to give hearing. But law is different, practical things are different. That's why I shared this judgment with you. Next slide, please. Revisional jurisdiction is discretionary and no one has right to be heard. It is for the court which takes up the matter for hearing as to whom hearing is given for best and proper decision of the dispute. See, the problem with lower courts is they don't give a speaking order. There are judgments which say that if you are dismissing a discharge, you have to give a speaking order. But then very few courts follow it. But at least a revisional court has to pass a speaking order, which means a detailed order explaining why. Let's say you go for a revision, and then the court has given a decision. You go for a revision. You cite some judgments, stating that to support my case, I'm citing those such judgments. And the court either allows the judgment or dismisses or doesn't, or allows the revision or it doesn't allow the revision. It doesn't matter whether it is allowing the revision or not allowing the revision. The court has to give reasons in support of such order by indicating application of mind. Mere repetition of words or language employed by the statute or used in the statutory provision is not enough. Relevant case law, State versus Janaki Raman. Next slide, please. Now, where revision is not a solution? What are the situations in which you cannot go for a revision? You either have to go for an appeal or you have to go for quash in such situations. Orders summoning witness, adjourning cases, issuing show cause notice, calling upon a party to execute interim bond, holding inquiry or investigation, issuing process against the accused, which is process is summons against the accused, committing a case, allowing or disallowing additional evidence, refusing to stay proceedings. So in such situations, you have to either go for an appeal or a quash, but not for a revision. Next slide, please. Now, where do you file revision? Orders, let's say you file a complaint, you file a private complaint for defamation or some other cases, and then the lower court dismisses it. What should you do? You have to go for revision. Discharging accused. Either way, either discharging or not discharging the accused, you have to go for a revision. Taking or refusing to take cognizance. Granting interim maintenance. There's an interim maintenance order. You are not happy with it. You have to go for a revision. Framing or refusing to frame charge against the accused. Order closing evidence. You have to go for revision. Next slide, please. Now, what are the limitations of revision? Before exercising revisional jurisdiction, the court must consider the character of the nature of disposal of a particular case by the inferior court, remedial action required to be taken by the revisional court, the ultimate social good of the community. Next slide, please. Limitation. The period of limitation for preferring a revision application to any court is 90 days from the date of order or sentence to be revised. Next slide, please. Any questions?
Yes, one question is there, but you already answered. The question was any timeline to file revision for a defective complaint.
Good, it's already answered. Good. To a case law which explains about the revisional judgment of the AP High Court. This is a case of forgery, alleged forgery, right? So what the Andhra High Court told for taking a decision whether charge or discharge the accused. Okay, let me tell the feedback. Let me tell you the what do you call it? Whatever. Let me tell you the background of this case. And there was an allegation against the applicant, against the revisional petitioner that he committed, etc. So they filed a discharge. The lower court dismissed it, stating that all the grounds which they thought are which they came out for revision are a matter of time. So they went for revision to the High Court in Hyderabad. And yes, for taking a decision whether to frame a charge or discharge the accused is not enough on the part of the trial court to merely peruse the final report or the complaint, but it has to examine all the material placed along with the final report or complaint. After considering the entire material available on record, if the court considers there is no sufficient ground for proceeding against the accused, then the court shall discharge the accused and record its reasons for doing so. It is not enough. See, this is the most interesting point. This is the interesting point. It is not enough that the contents of the final report or the complaint make out an offense. It is further necessary that there is facing material to show that the accused has committed the offense. The court has to scrutinize the material on record by applying its judicial mind, and for the purpose of framing a charge, it has to arrive at a positive opinion that prima facie case has been made out that the accused has committed the offense. For the purpose of arriving at a decision whether a prima facie case has been made out, trial court, while considering a discharge application, is not precluding it to taking into account inordinate, unexplained delay in lodging the FIR. This also can be one of the aspects which falls for consideration by the trial court while disposing of the petition filed seeking discharge. So, if there is unexplained delay in lodging the FIR, it is a ground for discharge. If the lower court has not taken it into consideration, you have to urge it again at the time of revision. Next slide, please. Discharge dismissals revised in favor of accused. Telangana High Court. C. Krishna Priya versus State of AP on 14 September 2018. In the recent times, various complaints are being lodged for the offences under Section 498A and Section 3 and 4 of DP Act, in which whether any allegation is made out or not, all the family members are being roped in and accused only for the purpose of harassing the innocent family members, whereby forcing them to come to terms. So, this observation by the Honorable High Court, by Honorable High Court of Telangana, which says that 498, most of the 498A are filed only to arm twist the husband and his family to come to their terms. When no specific who is the continuation of proceedings against her would amount to abuse of process of law, apart from putting the petitioner at undue hardship of facing the trial. As such, this court is inclined to interfere with the order passed by the court below in declaring the discharge of the petitioner. Next slide, please. Srimati Sarvamangala versus Station House. This is a judgment of Karnataka High Court. In the absence of specific allegations, though the omnibus statement made creates a suspicion, but not a strong suspicion in the conduct of the accused number 3 and 4, but on such omnibus statement itself, the court cannot come to a conclusion that it is a willful misconduct which is of such a nature that could be driven CW1 to commit suicide or to cause grave injury to her life, limb or health. Therefore, in the aforesaid circumstances, there must be a strong suspicion in order to frame charges. It does not mean that charges can be framed on the basis of suspicion alone. There must be strong suspicion which creates serious ground for framing of charges against the accused. Mere suspicion on the basis of omnibus statement may not be sufficient to frame charges against accused number 3 and 4. I think we are done. Dr. Vikas? Yeah. Thank you. For further info and doubts, that is my Twitter ID, my email ID.
Please, anyone have any question, please type on the YouTube chat. Prasaji, just give 3-4 minutes because we are getting we got only one question, so we will wait for more questions.
Okay, let me talk something about revision also, a little more. So my suggestion is more number of, if you feel that there is no prima facie case, go for revision. If revision is dismissed, go for revision. If discharge is dismissed, go for revision. Don't leave any scope. The right of fair trial includes the right not to be subjected to unnecessary trial when there is no prima facie case.
Okay, Prasaji, we don't have any questions from YouTube. Rudy,
Yeah, thank you, sir, for your wonderful session on criminal revision. We hope in future also we'll see such beautiful, wonderful, and very knowledgeable presentations from you. Thank you.
we got
Thank
one.
you.
Sorry, we got
Thank
one
you for Vikas Singh from Thane. Thank you, Dr. Vikas Singh Rawat and others to streaming and streaming on Twitter for Sai Surya, right? Yes. Thank you, everyone, for your support. Thank you.
Mr. Rodolph, there is a question. Dr. Vikas, you go ahead.
The question is same. What is the time limit to file revision?
90 days.
90 days. Okay. So, okay, I will like to conclude this session. So, thank you, Dr. Sarabjit Placer, and I will request everyone to subscribe our MyNation YouTube channel and upload this video. Thank you, everyone, for joining. Thank you, Placerji.
Thank you, Dr. Vikas. It's a pleasure.